Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me.
Hello and welcome to a special interview for The Wire. Earlier today, Rahul Gandhi was disqualified as an MP, and that disqualification has taken immediate effect. So today we ask, has Rahul Gandhi as a result become a victim of a lacuna or an anomaly in the law? On the one hand, Rahul Gandhi has a statutory right of appeal. That's one of his constitutional rights. But on the other hand, the disqualification that immediately follows yesterday's conviction has happened, and Rahul Gandhi has already paid a price. And this means that if the appeal were to find in Rahul Gandhi's favor, he would already have suffered damage and paid the price. Is that an anomaly? Is that a lacuna in the law? And does it mean that Rahul Gandhi has become a victim of this anomaly? Joining me now to answer this critical question is one of India's foremost lawyers, C. Aryama Sundaram. Mr. Sundaram, for the sake of the audience, let me begin by repeating that question and then I'll come to you for the answer. Rahul Gandhi's disqualification has revealed what I think might be an anomaly or a lacuna in the law. On the one hand, Rahul Gandhi has a statutory right of appeal. That's one of his constitutional rights. But on the other hand, the disqualification that follows his conviction yesterday has already happened. So, regardless of how the appeal goes, he's already paid a price and suffered. Would you accept this means he is a victim of an anomaly or a lacuna in the law as the law stands today?
Karan, according to me, the law as it stands is due to the Supreme Court in 2013 striking down Section 8(4) of the Representation of People's Act, which sought to protect people who had been convicted and who were sitting members for a period of time until their appeal was heard or otherwise. This was premised on a fact. This Section 8(4) was premised on the fact that you had a statutory right of appeal. However, I believe it overreached itself. It actually made it, never ending. So how long will the appeal take? Until then, he remains undisqualified and not subject to 8(1), 8(2), 8(3), which is disqualification, and it was struck down. But that, in my view, has, as you have pointed out, created a lacuna in the law because I feel there should be a sunset period, at least a short period, to enable him to file that appeal. Look, the anomaly is this. It is not a case of filing a special leave to petition, which is not a right to appeal. It is not a case of filing a revision, which is not really a statutory appeal. This is the case of a statutory appeal. That is to say, if you're convicted, you have a right to appeal, and the state has a duty to consider your appeal, which means the original conviction is not final. And the state itself feels that you deserve one appeal against that conviction in order that it either is sustained or reversed. But the lacuna here, according to me, is at least give a period of 30 days for a person to be able to file such an appeal and go to the appellate court and get whatever orders are possible of a stay or otherwise. But here, his disqualification takes place proprio vigore immediately. In which case, even if subsequently it is stayed or otherwise, he continues being disqualified for that period of time. What happens if the very next day there is going to be a vote of confidence and his vote is vital, and 2 weeks later the conviction is stayed, his vote was not taken? What happens if there's a vote on any important matter, if it's a budget which is being discussed? What happens in all those circumstances? So I do believe that as long as the statute grants him the right, and I use the word right, not the privilege, but the right of appeal, there should be a period of time enabling him to get to the appellate court and seek a stay, that he is not disqualified.
Let me repeat two critical things that you said. First of all, you agree that there is a lacuna or an anomaly in the law, and therefore today Rahul Gandhi has become a victim of that lacuna and anomaly. And the second critical thing you said is that even if the disqualification at the end of the appeal is reversed, nonetheless, for that duration before the appeal is heard, Rahul Gandhi will have suffered. And in his specific case, it means for the impending period, which is the budget session of Parliament, he ceases to be an MP. He cannot participate in critical parliamentary debates that will happen tomorrow, day after, or right up till the 8th of April when Parliament adjourns. And secondly, Wayanad has lost representation for that period as well. Both of those follow immediately from what you said, don't they?
Yes, unless and until he gets that conviction stayed. Because to expect an appeal to be heard within the next 2-3 weeks is really, I mean, it's utopian, and it doesn't happen. It's going to take years for the appeal. But he has to at least get the opportunity to get that conviction stayed, to show an appellate court that this conviction has a lot to be desired. The judgment has a lot to be desired. There is a strong case he's making out for appeal, so much so that the appellate court feels all right. And there are circumstances, consequences which will arise if the conviction is not stayed, and get the chance to convince a court that it should be stayed. He should, at least for that period of time, a limited period, however limited, 2 weeks, 3 weeks, 1 month, whatever, for that limited period, there should be a sunset clause by which he continues being a member without immediate disqualification. That's my view.
There is a precedent of fairly recent standing that could theoretically apply to Rahul Gandhi, and it's the case of the Lakshadweep MP, who was disqualified as an MP within 24 hours of his conviction. But the Kerala High Court then stepped in and stayed the judgment convicting him, and he was reinstated as an MP. If that happens in Rahul Gandhi's case, will he be automatically reinstated as an MP, or does the appeals court have to both stay the judgment and separately stay the disqualification? I.e., is it 2 stays that he requires, or will the stay of the judgment be sufficient to stay the disqualification as well?
There is a recent judgment of the Supreme Court in 2018 of a bench of 3 judges, and the court, speaking through Justice Chandrachud, in fact dealt with this question and said that if there is a stay of the conviction, the disqualification will cease to have effect. He was not talking about the allowing of the appeal. They were dealing with a case, A, whether a conviction can be stayed, B, when can a conviction be stayed, and C, would the effect of the stay of the conviction result in the disqualification also ipso facto coming to an end. And the court said that if the conviction was stayed, the disqualification can neither take nor continue in effect. So the effect of it is, if tomorrow his conviction is stayed pending the appeal, if the judgment is stayed pending the appeal, as from that moment, his disqualification will cease to have effect, and he continues being a member of Parliament.
Just to repeat that again, because I think it's critical, you were citing a Supreme Court ruling. I believe the year was 2019. I believe the judge in question was the present Chief Justice, Justice Chandrachud. And that judgment has very clearly said that if the conviction is stayed, the disqualification that follows from the conviction is also automatically stayed. which
It
means,
ceases to have effect, are the words he uses.
okay, that means that if in 2-3 weeks Rahul can get his conviction stayed, the disqualification will be stayed. But it also means that for the 2 or 3 weeks that it takes for that appeal to stay the conviction, for that period, he will have suffered. That suffering, that loss of a right to be an MP, which affects him and his functioning, but also affects his constituents in Wayanad, that suffering is irreversible. That has happened.
Absolutely, because for those 2 or 3 weeks, it's not only the member who suffers, his constituency suffers, his party suffers, and in a way, his non participation in the proceedings of the House also is deleterious to the public at large. I am not talking about Rahul Gandhi's case here or the importance of Rahul Gandhi. That is not what I'm talking about. I am saying that if any member of parliament who has been duly voted to parliament by a constituency who expects him to carry out their will or their hopes, if there is a party which has set up such a candidate to stand and which expects that candidate to support the party, and if the candidate himself is going to help in the advancement of law, I feel the anomaly is this: if you recognize that the stay will result in the disqualification ceasing to have any more effect from that day onwards, then why not give it a little period of time to, from the date of the judgment, to enable a person to be able to approach the appellate court and ask the appellate court for a stay? And that, I feel, is the anomaly.
Absolutely. And again, I'll point out for the audience something that you said, that why this anomaly or lacuna in the law is important is not simply because it affects Rahul Gandhi, an individual, although that is the circumstance in which we're discussing it. It's important because it affects the functioning of parliament, it affects our democracy, it affects his constituents in Wayanad, it even affects the nation because views that would be aired by an individual now can't be. Therefore, I come to my next question against that background. And you've hinted at this already. I'm now just asking you formally. Do we need to amend the law so that the disqualification will only come into effect after a decent but perhaps limited period of 2-3 weeks, thus giving the person affected a decent, meaningful chance of appeal? Do we need to amend the law to do that?
I certainly believe we do. I certainly believe we should, because it is today recognized that even if he has been disqualified, if 4 months later, let us say, that sentence is stayed, and not the sentence, the conviction, the judgment is stayed, he then comes back into being a member of parliament. So why do you have that period when he was not there, but now it's all right if he's there? The point I'm trying to make is this is a statutory right to appeal, and it's a statutory duty of the courts to hear his appeal.
Absolutely.
During
and I
that
want to underline that point you're saying. This is a statutory right, which means it is a constitutional right. It is not a privilege, as you said earlier. Because it's a statutory right, it becomes a fundamental right that must be enforced and given full play by the law.
Well, when we use the word fundamental right, we go into a different area. But let me put it this way. If it's a statutory right, it is a right which has been conferred by Parliament on the citizen. And the citizen has a right to demand that this right of his can be exercised. And my only point is this, that if once it is recognized that the court, the appellate court, can stay the conviction, and once it's recognized that such stay of the conviction will ipso facto mean that the disqualification will cease to have effect, I don't understand why a short period of time cannot be given holding such disqualification at bay to enable the person to exercise that right. And if he gets a stay, well and good. He does not get a stay, the disqualification takes effect.
Which brings me to my last question. You have very convincingly argued that we need amendment of the law, which will give a decent period of time. It could be 2-3 weeks, to ensure that the person affected can appeal and does not suffer and become, as has happened to Rahul Gandhi, a victim of an anomaly or a lacuna in the law. Now, the irony is that this is precisely what that ordinance in 2013 sought to do, which Rahul Gandhi tore up. Now, particularly as a result of what you said to me, we realize why that ordinance was so important.
Well, I hate to use the expression, but I'm afraid he's been hoisted on his own petard. I can't say anything else. It was a very sensible ordinance. And I feel that's an ordinance which should have been allowed to go through. And it's a pity that ordinance was then withdrawn by the government for political reasons. But the fact of the matter is this: I'm just imagining a situation where a person is disqualified today. Tomorrow, there is a vote of confidence. There is a trust vote. He is disqualified. He cannot participate in the trust vote, and the trust vote is either defeated or goes through by one vote. 2 weeks later, the judgment is stayed, and he's back in the house. And then you stop and think, well, if this judgment was going to be stayed, he could have been there for the trust vote, and, well, political fortunes would have been completely different. So I preface it again on this. Once it is recognized that a judgment can be stayed and not just the sentence. B, that stay of the judgment will result in any disqualification ceasing to have effect and the person continuing as a member of the House. I fail to see why a few days, a few weeks' time cannot be given for the appellate court to exercise its mind whether to stay the judgment or not.
I'll end there. Your conclusion, although you said it humorously, is that this development shows that Rahul Gandhi sadly is hoisted by his own petard. Mine is a little different. This conclusion shows that Dr. Manmohan Singh was right, and he was wrongly criticized for that ordinance. He was right in what he was doing because he had spotted an anomaly and a lacuna in the law which he was seeking to plug. I thank you for this interview.
I completely agree with you.
Thank you, Mr. Aryama Sundaram, for this interview. Take care. Stay safe.
Thank you.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me.